The Attorney General has faulted the Court of Appeal's verdict to stop the constitutional review process. The AG said the appeals court erred in stripping the president's immunity and his right to engage in political discourse. The president's chief legal advisor has asked the Supreme Court to overturn the Court of Appeal verdict, reinstate the president's stature as the BBI appeal got underway at the Supreme Court.
The Supreme Court began a three-day marathon hearing of the BBI appeals case. The Attorney General led the onslaught to resuscitate changes to the Constitution, poking holes in the Court of Appeal's ruling that declared the review initiative unconstitutional. The country's chief legal advisor warned that the Court of Appeal had stripped the president of his immunity while in office.
It is necessary that the president has decisional freedom to make decisions that are key and important to safeguard the interests of the country. My lords, if the president is detracted because of the fear that every decision he makes may attract civil liability against him, it would have a chilling effect on the ability of the president to make decisions that are important for the purposes of the people of Kenya.
The Attorney General fiercely defended the president's involvement in the push to review the Supreme Law, saying he was within his rights. This in contrast to the Court of Appeal verdict.
The only way that the rights of the president to participate in the initiative or the process in Article 257, the only way they can be limited is that the person who is seeking that limitation must demonstrate compliance with the provisions of Article 24 of the Constitution. No such demonstration has been done by any of the parties or by the Court of Appeal itself.
The AG defended the distribution of the 70 new constituencies in the BBI bill, saying the move in no way infringed on the mandate of the Electoral Commission as ruled by the Court of Appeal.
The people deliberately removed the mandate of allocation of constituencies from commissions and reserved this for themselves. Why? Because the problem that was noted in the Kriegler report was brought about because the issue of constituencies was left entirely to the ECK, to an independent commission.
IEBC submitted that the Court of Appeal got it wrong in its verdict that the commission was not properly constituted, asking the Supreme Court to remedy the position and safeguard the independence of the commission.
IEBC was always properly constituted. It had the quorum mandated by the Constitution itself. There can be no higher law than the Constitution itself.
With the Court of Appeal indicating that the Commission did not undertake public participation on the BBI referendum bill, IEBC submitted that public participation was not under its purview.
What then would be the position when IEBC, in the course of conducting the referendum, would have also taken it upon itself to be the one to speak about the pros and the cons of the bill? Would we not be seeing a situation where there's conflict on this this institution that is supposed to be independent and impartial?
The Attorney General and IEBC's case seeks to overturn the decision that muted the push to change the Constitution was backed by the BBI Secretariat and Azimio la Umoja movement leader Raila Odinga. President Uhuru Kenyatta presents his case on Wednesday. Samogina, Citizen TV, Nairobi.